Away from that and to an issue that we've been following over the last at least 72 hours, President John Mahama has provided copies of the petitions from the three individuals to the Chief Justice, and this is what the update to this situation that has been evolving since Tuesday evening. So yesterday we got to know of that request by the Chief Justice for the copies of the petition, the three petitions against her. Well, what we're hearing today is that President John Mahama has provided copies of the said petitions from these three individuals to the Chief Justice Gertrude Torkornoo. The President has also subsequently given the Chief Justice 10 days to respond to the petition seeking her removal. Now let's get a background to this. Three separate individuals petitioned the President to remove the Chief Justice from office. The content of the petition is, however, not known. The President, per constitutional requirement and as confirmed by the Minister of Government Communications, Fides Kwatiofosu, confirmed that three petitions have indeed been forwarded to the Council of State in line with Article 1466 of the 1992 Constitution. The Chief Justice, however, wrote to the President requesting to be given copies of the petitions against her submitted to the President before conclusions of consultations between the President and the Council of State under Article 146, Clause 6. Now, Justice Torkornoo based her request on the common law principle of natural justice, where a defendant must be given hearing before proceeding to arrive at a decision. Dennis Probert Wadam Esquire is with me in studio. Is with the legal and political desk here, heading the research in there for us here at TV3 and on 3FM 92.7. It's good to have you, Dennis Probert Wadam. Talk to us. Let's walk us through really what is contained in the said letter from the President, essentially responding to some of the issues that happened yesterday.
Well, so Alfred, the highlights of this particular letter from the Presidency to the Chief Justice to the effect that she would be given the opportunity, in fact, to respond to the petitions that have been made available to the President in respect of her removal. You know, this has become a matter of controversy. Yesterday, since some persons decided to go to court seeking that the right procedure ought to have been that the President should have sent the petitions to the Chief Justice, asking her to respond to same before the consultation with the Council of State. However, I mean, the whole of yesterday was when that should be done, how it should be done, and all of that. However, the good news and what is refreshing is the fact that the President has now given that opportunity to the Chief Justice and explained the circumstances under which he came to this conclusion, and that it was already the intention of the President to have given her the opportunity to respond. As part of this letter, we get to now begin to see some new facts emerging. For instance, we didn't even know when the petitions were put before or were sent to the Presidency. But from the letter, we are told that two of them were dated 14th February 2025, and then the third one was dated on the 17th of March 2025. Beyond that also, so the President explains that when he was forwarding the letter, the petitions to the Council of State, he did indicate that per what he knows, he intended to give the opportunity to the Chief Justice to respond. He said he only got that response on the 27th of March. 27th was yesterday.
Yes,
it was
right.
also the same yesterday that the Chief Justice wrote to the President requesting copies of the petitions. That is to say that while the President was waiting for the response of the Council of State to give him the green light to forward the petitions to the Chief Justice for a response, the Chief Justice, who also have heard about the petitions right from Tuesday, which was on the 25th, was also worried about the fact that there were petitions against her that she got to hear from the statement from the Presidency but did not get the petitions. 2 days on, she also wrote to the Presidency. At the same time, when she was writing to the Presidency for the petitions, the Council of State had also written to the President to say that, yes, we have given you the green light to forward the petitions to the Chief Justice. So it's the whole situation looks a bit complex, but if you unpack the issues, you can understand why there seemed to be that kind of confusion because of the time lapse. Because as at the time one person was doing one thing, the other person wasn't in the know. But bottom line is that the President has now said that, okay, petitions be forwarded to the Chief Justice, give her 10 days to respond, and then we take it from there. What is however unclear is now the fifth of these legal actions that are pending before the courts. At least we know 2 writ of summons and then an injunction application which is expected to be heard on Wednesday next week. It's uncertain how that is going to pan out. But if you look at it on the face of it, it does appear that the matters in contention would have been resolved by the president's new letter to the Chief Justice, giving her the petitions and asking her to respond to same.
I see, because the crux of that injunction by Vincent Asifua was that the Chief Justice should have been in the known, and as a result, the process should be put on hold until she is put in the known, is it not?
Yes.
Essentially.
Yes.
So now that she's in the known, does that render the injunction moot?
That's really would lie with the courts, and of course also with the applicant in this matter, applicant in respect of the injunction application. And that's because there are two ways. If the court itself deems that the matters have already been resolved, the court may consider the whole application moot. Again, even if before the court even makes a determination, the applicant thinks that the issues that have been raised in that application for the injunction have also been resolved, they may also consider withdrawing that application, and then they proceed. If they still want to go ahead with the writ of summons itself, they can do so. However, again too, if they also proceed with it and the court thinks that the matters have been resolved, it can also consider that also as a moot matter. But that's why I'm saying that the future looks uncertain. It's largely dependent on the plaintiffs in this matter and also largely on the courts.
And you know that I was asking a question yesterday of you and Christian Mamhesi, that there are those who held the view that both the Chief Justice and Vincent Asifua probably were just going ahead of themselves, because to the extent that the process is still in motion, it was just a matter of time that, you know, she was going to be put in the known of the details of the said petition, and that's what's happened now.
But like I explained, sometimes the law actually it's advisable that you are proactive rather than being reactive. That is to suggest that, and like we saw in the timelines, the Chief Justice, she got to know of it on Tuesday. On Wednesday, she had not got the petition. Thursday, she took a step. So where there is a likelihood of a breach of your right or the Constitution, you can take steps to protect same. It's not always the case that you have to wait for the harm to be done before you go to seek a remedy. So within that context, that explanation really will not be entirely true. It's an option that yes, she could have waited, but also it's not out of place for you to take a step early enough. It's preemptive protection, if I may call it that way. So I mean that matter really is neither here nor there.
Wonderful point then, and 24 after 5. And let's stay a bit further on this, because a number of persons who have also been sharing their thoughts on this particular development and how the way forward will look like from today. So essentially, Dennis, what the president is saying is that 10 days from now,
yes,
he expects a response to the petitions, all
yes,
three, from the Chief Justice.
And it's also instructive to know that the Chief Justice herself was asking for 7 days. When she wrote a letter to the presidency asking for the petitions and also to be given the opportunity to respond, she wanted 7 days to do so. Now the president largely has added 3 more days to that. So the expectation is that once that is done, then the consultation process can progress to a point where, the outcome of that consultation process largely will inform the next line of action as to whether there will be a committee to be formed or not, and all that comes thereafter under Article 1466 of the 1992 Constitution.
Perfect point. Now, but for the number of days given for the response, that is not also explicitly stated in the Constitution, is it not?
Yes, we explained that yesterday on Ghana Tonight, that unlike the OSP, where now that law, which is relatively new by the way, has actually provided for timelines that within specific periods of time, certain things must be done. When it comes to the case of the Chief Justice, as provided for under Article 1466, it does not expressly state what should be done at what period of time. It only gives a roadmap as to what should be done. So, it's largely within 10 days for the Chief Justice to respond to the petition, for a primary consultation to continue. That consultation, per the decision of Frank Ejechum and the Attorney General, should include the determination of a prima facie case. Thereafter, the committee will be put together, and then they will take it from there. We do not know how long this process may last because, like we said, no timelines have been indicated in the Constitution. But as much as possible, all the necessary things that need to be done as provided for in law should actually be complied with.
So Dennis, stay with me a bit. So now, Now that this conversation is evolving in a very interesting way, Christian Mamahese is private legal practitioner joining us on the telephone right now. Counsel, appreciate your time. As we do know now, President Mahama has given the Chief Justice 10 days to submit a preliminary response to the 3 petitions calling for her removal from office. She was asking for 7 days yesterday. President has given her 10 days. And even going ahead to assure her that indeed due process will prevail in handling the said petitions against her. Now, how does all of this strike you?
I mean, it is in the right order. It is in the right order. And indeed, these are some of the arguments that Dr. Dateba had espoused in the Duchum case. It is in the right order. And indeed, as I had mentioned in previous days, you see, the contributions of the Chief Justice in her response would cause the determination of a prima facie case, and thereafter the hearing would begin. If it is satisfying that the content thereof is anything to go by. So I believe that the tenets of natural justice has been established as far as this particular matter is concerned, and also the required stage of prima facie to be determined before the hearing is done or is carried out to seems to be in order, because that is what is rightly unfolding before our eyes.
I see. Now, also, there was an injunction that was filed yesterday by Vincent Asifua. The crux of that injunction was that the whole process should be put on hold until the Chief Justice is put in the known of the details of the petition against her. Now, she has copies of all 3 petitions against her and the details thereof. What becomes of the petition by Vincent Asifua?
I mean, ordinarily, by law and procedure, that particular injunction is rendered moot because, you see, injunction by tribes law is discretionary, and as discretionary as it is also timeous. It should be brought timeously, such that if the act that one is seeking to injunct has already been carried out, then there is nothing to injunct. If you look at the High Court rules, CI 47 Order 25, it deals copiously with the procedures for injunction. And so, which it mentions the elements that I am talking about. So, indeed, once that which he was seeking to deal with or have cured is currently underway in accordance with the tenets of law, that particular application is rendered moot.
Counsel, I appreciate your time on this, and I know that this evolving matter has also led to some making the call that there has to be a consideration of a review of that particular provision in our Constitution. Is it one that you would support?
Yes, it's one that I support, and there has been some work in that direction. You realize that there is the omission of who carries out prima facie establishment. And I had mentioned in previous days that is an anomaly. But you see, in constitutional interpretation, we deal with what we call the objective purpose and then the subjective purpose. The objective purpose deals with the spirit of the Constitution, and the subjective purpose deals with what the framers actually intended those provisions to mean. And so in construing the objective purpose, we look out for the history, the history, whether history simpliciter or the legal history as far as those provisions are concerned, or anything relating to that. We also look at the core legal values or the legal systems, and then we now look at the general provision, and then we balance the two in order to establish whether the interpretation of it would make it absurd. Now, in coming to that conclusion, it requires that a prima facie ought to be established before the hearing begins with that particular committee. And these are the very things that Dr. Dateba argued. So we are having legal procedures pan out, and we believe that it will continue to the end. And at the end of the day, when justice is served, it is Madagana that wins.
Okay. I do appreciate your thoughts on this. And Alhaji Nusaf Hussaini is joining us right now as well for a conversation on this. He is a private legal practitioner, so is in good standing, former member of parliament, former minister, lands and natural resources, many other ministries, and contributing his quota to the development of this country. Alhaji Nusaf Hussaini, thank you so much for joining us.
Thank you, Ocansey, for having me.
Long time. It's been a while indeed. Now, you make the argument that the president did nothing wrong in forwarding the petitions to the Council of State, even at the blind side of the Chief Justice. But now, this development, as the president has now made her aware of the details of the petition and then also forwarded copies to her, you still stand by the same point?
Oh, yes. Now, so the Chief Justice wrote to the president that she wanted the copies of the petition so that she could prepare her response. And the president is minded to give her copies. Simply portrays the president as somebody who has no ill intent against the Chief Justice, just doing his constitutional duty of forwarding the petition to the Council of State for the establishment of a prima facie case. So if the Chief Justice's case would be better enhanced, or if the forwarding the petitions will make it more transparent and accountable, the president thinks we do that. I mean, these are private citizens of this country who have petitioned the president for the removal of the Chief Justice. It is not the president who is asking for the Council of State to remove the Chief Justice. And so what the president has done is a feather in the cap of the president.
I see. Now, you say it's a feather in the cap of good governance.
Yes.
But then again, it was something that was bound to happen. It was supposed to happen, is it not?
No, it was not bound to happen.
Why is that?
Why? Because it was a prima facie case. I mean, you look at the Tabas rule, I've heard the person you called, he clearly, the establishment of the prima facie case is to sieve, is supposed to act as like a sieve, to sieve out frivolous and vexatious petitions. In the whole scheme of things, is to protect the dignity and sanctity of the office of the Chief Justice and ensure that the independence of the judiciary is maintained. And so, if there are frivolous and vexatious petitions, the president, in consultation with the Council of State, can see into it and say, well, this petition discloses no reasonable course of action against the Chief Justice, and so we are not going to set up a committee, even without recourse to the Chief Justice.
I see. Without recourse to the Chief Justice, wouldn't that be a violation of Article 19?
Article 19 is fair. What is Article 19 saying? Fair trial.
Exactly. So, just on the orders of natural justice, at least, so that the other person gets to know.
You are saying Article 19. Article 19 is fair trial. But this is not a trial yet. We have not gone there yet. When the president Akufo-Addo dismissed the petition of Professor Kokwaza, a day before he left office, did he forward the petition to the Chief Justice? Did he do that?
No, well, not that we know of.
Yes, I'm just saying that these are preparatory stages. Primary, like the Tabas said in his judgment, primary stages of the process. And clearly, no mischief will be done if the Council of State, and the Taba makes it clearly, they must play a very important role in determining whether there is a prima facie case. The Council of State. Because of the principles of separation of powers. And clearly, our Constitution, our history, our core values are founded on the independence of the judiciary and the principles of separation of powers.
Rightly so, but then again, there have been that argument, and earlier, before the president made these copies aware to the Chief Justice, the concern was that, at least on the principle of natural justice, you cannot proceed on this path of establishing prima facie without notifying the person on which these accusations are made against.
Who has told you that? And so what? So I just cited to you the case of President Akufo-Addo dismissing the petition of Kokwaza without recourse to the Chief Justice on the grounds that the petition of Professor Kokwaza disclosed no reasonable course of action. So did the president breach the rules of natural justice?
And there's a question that I'll ask Mr. Christian Hesimam on the other line. How about this particular argument as well, Mr. Hesimam?
Yes, hello, I'm here.
I can hear you clearly. Now, you hear Enusa Fuseni make that point that to the extent that in the case of Professor Kwaku Azar, for instance, the former president did not necessarily consult or seek the views of the current Chief Justice before dismissing the petition of Professor Kwaku Azar. It cannot be stated that it is a rule that the Chief Justice should be consulted in the process of consultation by the by the Council of State in determining a prima facie case.
I honestly would endear my colleague, my learned colleague, to read the full judgment of Dr. Dateba that was also concurred by the then leadership, Georgina Wood, in the case of Frank Educhum and the Attorney General. And the fact that that situation happened does not mean that it is a blanket situation. And the learned jurist gave a lot of scenarios and went deeply into comparative legal analysis on interpretation, approach of interpretation, and considered Article 146 copiously. Now, it considered Article 146 in relation to a lot of cases, considering the New Patriotic Party case versus Attorney General. It considered also the Ghana Bar Association and Attorney General in respect of the removal of Aban CJ, and dealt with other constitutional cases, considering Tufo and Attorney General, Kunehia versus Acha.
But brother, the cases are the judgment.
Yes.
And the judgment.
And
the question is,
respectfully, we are on a major platform, and I pray that we talk in alternate order so that the public could hear the informed submissions that we are making. Other than that, we will not be able to make any headway. There will be contortion in whatever we are putting out there. Yeah. So what basically I'm saying is that when the Constitution must be read as a whole, and the major authority is coming from that judgment, and indeed the person that you are accusing in respect of removal has to know what the situation is, must know what is being said of him or her, to the extent that it went to determine that the time that the prima facie ought to be determined. You asked of me of that yesterday. It says that the Constitution as we have it omitted. The framers omitted it. Now, in construing it if we construe it literally, it would render the interpretation absurd. So it is not that the president is doing us a favor by running it to her, or is good governance like he's saying. Yes, once it's following in accordance with law, it's appreciated, and it also has a part on good governance. But it is not a gratuitous gesture that one is carrying out and say, thank you for doing it for me. Indeed, it could probably be construed that if the Chief Justice had not written to the President for such a legal remit to be considered, it may or may not even come up. So we should appreciate the procedures as they are going, and it should be devoid of any form of prejudice or motive.
You have just one.
I see. Well, it's a matter that is playing out, and it's one that in the coming days we will see, because the Chief Justice, as per the President's letter to her, has 10 days to respond. So this is what we'll keep an eye on as well. Christian Mamhesi, private legal practitioner, thank you. To you as well, Haji Nusa Fuseni, I thank you very much for joining us, a private legal practitioner, a former member of parliament, a former minister of the Republic of Ghana, holding many portfolios as well, joining us on this matter. But CCTV footage